Lawyers, what's the most ridiculous case you've ever handled? Story 1. It was a typical day at the law firm when I received a call from reception. They informed me that someone had arrived, seeking intellectual property advice. As I made my way to the reception area, I tried to prepare myself for whatever might come next. It's always a bit of a mystery who will walk through those doors and what their story might be. When I got there, I saw a woman standing nervously with a small wheeled suitcase by her side. She had a noticeable facial twitch, and there was something off about her demeanor. It was clear that she was disturbed, but I couldn't quite put my finger on what was going on. Despite my initial concerns, I escorted her to a conference room, making sure to keep the door open and maintain a clear line of sight to reception, just in case. We sat down, and she placed the suitcase on the table. With a somewhat frantic energy, she unzipped it and revealed its contents. A thick stack of thousands of handwritten pages, and bizarrely, one half of a pair of scissors. It struck me as odd. Why only one half? But before I could ponder it further, she launched into her story. She explained with a fervor that was hard to ignore that she had written a manuscript detailing how the city council had somehow given her schizophrenia and hepatitis. As if that wasn't enough, she claimed that aliens had stolen her pet, and it was all part of a larger conspiracy involving the army and the Illuminati. It was a lot to take in, and it was clear she believed every word she was saying. Her primary concern was that the local newspaper was plotting to steal her thoughts and publish her manuscript without her permission. She wanted to register the copyright for her work to protect herself. Despite the surreal nature of her claims, I knew I had to handle the situation delicately, especially given the presence of the scissor. I took a deep breath and explained as calmly and rationally as possible that in our jurisdiction, copyright protection automatically exists upon the creation of a work. She didn't need to register it to have rights as an author. I suggested practical steps she could take to protect her manuscript, such as sending a digital copy to herself and a trusted friend, as well as leaving a physical copy with someone she trusted. This way, if her work was ever published without her consent, she could prove it was hers. We discussed these steps for nearly an hour. Despite the bizarre nature of her beliefs, she was receptive to the advice and seemed relieved to have a plan in place. As our conversation wound down, she thanked me for my help. I felt a mixture of relief and concern as she left the office, wheeling her suitcase behind her. I was grateful that the encounter had gone smoothly and that I'd managed to provide her with some peace of mind without any incident. Handling situations like these requires a delicate balance of empathy and caution, and I sincerely hoped she found the help she needed. As she walked away, I couldn't help but reflect on the strange and often challenging nature of my work. It's not every day that a lawyer has to deal with conspiracies, aliens, and half a scissor, but it's all part of the job. Story 2. As an immigration lawyer, I've encountered my fair share of people trying to manipulate the system, or who conveniently forget to disclose critical information. But one pro bono case stands out in my memory for its sheer audacity. The client was a Chinese national claiming asylum on the grounds of religious persecution. She presented herself as a devout Christian, asserting that if she were sent back to China, she would face severe persecution. She detailed how she and her family had been harassed by local police and how members of her church congregation had been arrested. At first glance, her story seemed legitimate, aligning with numerous real cases I've seen over the years. She provided statements and documents describing her plight and the names of people involved. As I went through the paperwork, something felt off. The names and places rang a bell. A quick search on Google confirmed my suspicions. These were details from one of those notorious bot stories. For those unfamiliar, bot stories are essentially pre-packaged sets of documents and narratives sold on the internet to individuals seeking asylum. They're based on real cases that have successfully obtained asylum, and someone had managed to get their hands on the original documents. These are then mass-produced and sold, with the expectation that the buyer will modify the details to fit their personal circumstances. Unfortunately, my client hadn't bothered to change the names or any of the specifics from the original case. Adding to the oddity, the supporting documents referred to her as male. At first, I chalked it up to a possible translation error, but the inconsistency persisted in the original Chinese documents. It was clear that she had copied the story verbatim without any effort to make it her own. This blunder not only undermined her credibility, but also put her in a precarious position legally. I was both amused and disheartened. On the one hand, it was almost comically lazy to present a case without changing even the most basic details. On the other hand, it was a stark reminder of the desperation some people feel resorting to such tactics to secure a better life. Needless to say, I didn't take her case. It's unethical and risky to present false information to immigration authorities, not to mention illegal. Moreover, her claim of religious persecution felt dubious, as the situation for Christians in China isn't uniformly dire. While there are certainly cases of discrimination and harassment, Christianity is also one of the fastest growing religions in the country, with a significant number of believers practicing openly. This case was a fascinating glimpse into the lengths some will go to manipulate the system, but it also highlighted a lack of judgment. Using a prefabricated story, especially one that's been circulated and potentially flagged by immigration officials, is a dangerous and ineffective strategy. It was an eye-opener for me, reinforcing the importance of diligence and authenticity in legal representation, especially in such a sensitive area as asylum law. Story 3. In my line of work, I hand out a lot of business cards. Inevitably, they sometimes end up in the hands of some rather questionable individuals. One such individual was Mr. Bob, obviously not his real name, but it fits the story. Mr. Bob was a character unlike any I had ever encountered before. One day, he approached me with a rather unique request. He wanted to sue the federal government. Not just one branch, but the Department of Defense, the Department of Homeland Security, the Secretary of State, the entirety of Congress, and the President himself. As soon as the words left his mouth, my guard went up. The sheer absurdity of his request made me wary, but instead of dismissing him outright, I decided to dig a little deeper. "Why do you want to sue all these parties?" I asked, trying to keep my tone neutral. Mr. Bob's eyes lit up as he began to explain. He claimed that the government had kidnapped him and subjected him to a series of painful experiments. According to him, these experiments were conducted in collaboration with the reptilians, an alien race working alongside the government in a grand, sinister plot against humanity. He detailed how he had endured immense suffering at the hands of these experiments and how he had only managed to escape with the help of a reptilian double agent. After laying low for a few years, he had finally come to me for help. At this point, I was done. The story was far too outlandish to entertain any further. I asked Mr. Bob to wait in the lobby while I made a quick phone call to the local police department. I wanted to ensure he hadn't escaped from a prison or a mental institution. Surprisingly, he hadn't. When I returned to him, I decided to let him down gently. "Now, Mr. Bob," I began, "if these government officials are indeed working under the reptilians, that would mean they have revoked their American citizenship. They would then be subject to intergalactic law, which is outside my area of expertise. I specialize only in American law, so I'm afraid I can't help you." He seemed genuinely disappointed, but accepted my explanation without causing any trouble. He left quietly, leaving me with one of the most bizarre encounters of my career. That day was both the best and the worst of my professional life. It was a stark reminder of the kinds of people and stories you can encounter when you put yourself out there. But it also made for a great story to share at parties, one that never fails to get a laugh or two. Story 4. I've heard all kinds of bizarre stories in my career, but there was one that stood out as both surreal and unsettling. I had heard rumors about this man before actually meeting him, tales that seemed too outlandish to be true, until he walked into the lobby of my office one day, causing a commotion that startled the receptionist. He was in his late 50s or early 60s, clearly mentally disturbed, with a wild look in his eyes. He approached me with an incredible story. He believed someone had implanted a device in his brain that controlled his behavior. According to him, this device was being manipulated by none other than Baskin-Robbins and a former mayor of Detroit. He was convinced that these forces were making him do all sorts of things against his will, from drinking at bars to taking wrong turns while driving. They even allegedly forced him to retire from his job. As he spoke, his voice filled with paranoia and conviction, I felt a mix of concern and helplessness. He insisted that he was being controlled and that doctors were part of the conspiracy, refusing to see them out of fear they were in on it. After listening to his story, I gently explained that I couldn't help him legally and suggested he might benefit from seeing different doctors. He grew visibly upset at this, clearly mistrustful of medical professionals. Before leaving, he asked if I knew any lawyers specializing in cases like his. I gave him a referral, knowing deep down that what he really needed wasn't legal advice, but psychological help. It's a sad reality that sometimes people who come to us for legal help actually need something much deeper and more complex. This man didn't need a lawyer. He needed compassionate care from mental health professionals who could address his delusions. It's cases like these that remind me of the limits of the law and the importance of understanding the broader context of the lives we intersect with. Story 5. In my career, I've had my fair share of eccentric clients, but none quite like the man I met at a bar one rainy evening. He didn't sound off on the phone, seemed perfectly reasonable, in fact. But as soon as we met in person, the extent of his issues became glaringly apparent. The man wanted to sue just about everyone in his life. His ex-wife was already embroiled in a legal battle with him, but that was just the tip of the iceberg. He wanted to go after her lawyer, the judge who granted her custody of their children, his church for excommunicating him after she got a restraining order, his bank for letting her access their joint accounts, and his cell phone company for not canceling her number before the divorce was finalized. The list went on. The kicker was when he revealed he wanted to sue his doctor for diagnosing him with paranoid schizophrenia, claiming it was all part of a grand conspiracy to ruin his life. He was convinced everyone was colluding against him. As he laid out his plan, he insisted I take the case on a contingency basis. "There's a lot of meat on these bones," he said. "We can go halfsies on whatever we win." I remember cringing at the word halfsies, a term that felt out of place in such a serious conversation. Listening to him, I couldn't help but feel a pang of sympathy. It was clear he was under immense stress, likely exacerbated by a serious mental condition. But the sheer number of people he wanted to sue, each with its own set of improbable accusations, was staggering. I knew I couldn't take him on as a client. It wasn't just a matter of the workload or the implausibility of his claims. It was about not enabling what seemed like a descent into further paranoia and delusion. Gently, I tried to reason with him. "You have to consider," I said, "that it's statistically improbable for all these people to be conspiring against you. It might be worth seeking a different kind of help to navigate through this." He didn't take it well. His eyes flared with a mix of anger and desperation. "You're in on it too, aren't you?" he accused, before storming out of the bar. I left that meeting with a heavy heart. I hoped he would find the help he clearly needed, even if it wasn't legal assistance. It was a sobering reminder of the fragile line between stress and mental health issues, and how easily one's life can spiral out of control under the weight of personal turmoil. Story 6. I usually avoided criminal defense cases, but then Dennis walked into my office. He was facing charges for driving while intoxicated and aggravated unlicensed operation of a motor vehicle, both misdemeanors. Dennis was a wiry man in his late 50s with a disheveled appearance, and he was adamant. He swore up and down that he didn't drink, had never driven the vehicle in question, and insisted he had a valid driver's license. As I listened to his passionate denials, I couldn't help but feel a pang of skepticism. Still, I gave him the benefit of the doubt and provided the names of several local criminal defense and DWI attorneys, but Dennis refused, saying I was the lawyer he wanted. Looking back, I should have realized he had likely been turned down by other attorneys and had come to me as a last resort. I agreed to take a preliminary look at his case, charging him a $200 intake and record review fee. I contacted the local court, police station, and district attorney's office to gather information and paperwork. The facts were pretty damning. Dennis had blown a 0.18 on the breathalyzer, well over the legal limit. When he continued to insist he wasn't drunk, the police had taken a blood sample, which revealed a BAC of 0.22. As for his claim of not driving, the police report told a different story. 2 squad cars had witnessed Dennis's vehicle plowing over a mailbox and then driving off. They followed him and pulled him over a block later. According to the report, Dennis was the only person in the car, securely fastened in the driver's seat with a seatbelt. And as for his license, it had expired 3 years ago and had been suspended for 2 years before that. When I called Dennis back into my office and laid out the facts, he seemed taken aback but quickly concocted a new explanation. He admitted he might have been drunk, but claimed he had been unaware of it. His son, he said, must have spiked his green tea with Fireball whiskey, and he hadn't noticed the whiskey's taste because he was eating red-hot cinnamon candies and had a cold, which left him with a stuffy nose. Despite the overwhelming evidence against him, Dennis retained me. He insisted on going to trial, convinced the judge would see things his way. I had him sign an engagement agreement clearly stating that I had explained his low chances at trial and that he understood there was no guarantee of a win. At trial, Dennis opted for a bench trial over a jury trial. He believed the judge would be more understanding of his situation. I made sure he signed another document affirming his understanding of the difference between a bench and jury trial to protect myself legally. As expected, we lost the case. The evidence was simply too strong, and Dennis's convoluted defense didn't hold up. The judge handed down a probation sentence, which, in the grand scheme of things, was a relatively lenient outcome. I had hoped to convince Dennis to accept one of the plea offers extended to us, but he had been adamant about going to trial. After the verdict, Dennis was visibly disappointed. He had been so sure that his version of events would clear him of all charges. His confidence was misplaced, and reality hit hard. But the story didn't end there. Dennis later tried to sue me, claiming inadequate representation. His evidence? The judge's guilty verdict. The case was quickly dismissed, as it had no basis. Dennis had jumped through all these legal hoops, clinging to a narrative that was far from reality. It was a frustrating case, one where I knew from the start the odds were not in our favor. Despite all his certainties and convictions, Dennis learned the hard way that sometimes you have to face the facts, even if they're not what you want to hear. Story 7. I remember the case like it was yesterday. I was working at an auto insurance defense firm in Florida, a place infamous for its murky legal waters. My job was to represent a particularly despicable insurance company in personal injury protection, PIP cases. These cases were typically battles between chiropractors and insurance companies, involving the most basic level of car insurance required to keep your vehicle legal on the road. It was a cesspool of legal maneuvering and questionable ethics. The system worked like this. Ambulance chasers would funnel accident victims to chiropractors they recommended. These chiropractors would then rack up nearly $10,000 in treatment costs, just shy of the maximum coverage limit. The victims, often lured by promises of free massages, went along with it. The chiropractors would submit their inflated bills, the insurance company would balk, and a lawsuit would ensue. Thousands of these cases were always in play. The law favored the chiropractors. If they recovered any money, they were entitled to attorney fees, which made plaintiffs' attorneys eager to take on these cases. The insurance company would counter with medical checks, expert witnesses, and record requests, reducing the bills by a few $1,000s at the cost of thousands more in legal fees. Meanwhile, the chiropractors earned 11% interest on the unpaid bills. It was a goldmine for everyone involved, except, of course, the insurance company, which passed the costs onto the consumers. Despite the absurdity, it was a fertile ground for a young attorney to cut their teeth on civil litigation defense. Sometimes the insurance company would push a case to trial, aiming to set a precedent or simply to hassle the opposing counsel. One such case was the tipping point for me. Our client was a poor young woman of color, living in a low-income neighborhood. She was 9 months pregnant when she was rear-ended at a four-way stop by an on-duty police officer in his patrol car. It was a low-speed collision, but given her condition, the cop did the right thing and called an ambulance. She hit the steering column, so they took her to the hospital to ensure both she and her baby were unharmed. Thankfully, they were fine and she gave birth without complications later. After the accident, she sought treatment from a chiropractor, accumulating the usual $10,000 bill. The insurance company wanted to take this to trial, arguing that she wasn't injured in the accident and merely sought post-childbirth massages. The absurdity of their demand left us flabbergasted. They expected us to subpoena this poor single mother, put her on the stand, and somehow extract a confession that she wasn't hurt, merely experiencing woman pains. They also wanted us to subpoena the police officer who hit her and make him testify that taking her to the hospital was an overreaction due to the low-speed nature of the collision. Essentially, they wanted him to admit he was covering his own behind. We knew how this would look to a jury. After a week of back and forth, the company finally agreed to settle. I resigned shortly after that case. The entire experience left a sour taste in my mouth, and I knew I couldn't continue in a profession that often felt so ethically compromising. Now, I own a brewery. It's a different kind of challenge, but infinitely more fulfilling than being a lawyer ever was. Story 8. I remember the day I took a call from a potential client. It was one of those gray, rainy afternoons that make you want to curl up with a good book. The woman on the other end of the line had a peculiar situation. As a personal injury lawyer in the UK, I'm used to hearing all sorts of stories, but this one stood out. She sounded flustered and a bit embarrassed as she explained that she had fallen down the stairs in her own home. The cause? Her cat. It seemed she had tripped over the poor creature while navigating the steps. Now, you might think she'd be upset with herself or maybe the cat, but no, she had a different target in mind for her frustration. The house she lived in was council-owned, and as part of her lease agreement, she wasn't supposed to keep any pets. This, however, hadn't stopped her from adopting her feline friend. Her argument was that during a routine inspection of the property, no one from the council had explicitly told her to get rid of the cat. Therefore, she believed it was the council's fault that she had tripped and fallen. She wanted to sue them for her injuries. I listened, trying to keep a straight face, while she detailed how the council's lack of enforcement of the no-pet policy had led to her unfortunate tumble. As ridiculous as it sounded, I had to consider her perspective. But ultimately, I knew there was no legal basis for her claim. It was one of those situations where personal responsibility couldn't be transferred to someone else, no matter how creative the argument. Politely, I explained that we couldn't take her case. As I hung up the phone, I couldn't help but chuckle at the absurdity of it all. It's not every day you get a call from someone wanting to sue over their cat-induced accident. Story 9. Another memorable case involved a gentleman with a rather unique approach to his road traffic accident claim. When he first came into my office, he seemed very determined, almost intense. He sat down and, without much of an introduction, pulled out a piece of paper. I could see the passion in his eyes, and I braced myself for what was coming. He told me he had written a poem about the accident. Not just any poem, but one in a language called Yuba. I'll admit, I had never heard of Yuba before that day, and I'm pretty sure he saw the confusion on my face. I tried to ask him to just explain the facts of the case, but he insisted on reading the poem. He began reciting, his voice rising and falling with emotion. As he spoke, I felt like I was in an entirely different world. The problem was, I had no idea what he was saying. I don't speak a word of Yuba, and from the looks of it, he wasn't from West Africa either. Yet, there he was, passionately delivering his verse. It went on for nearly 20 minutes. I watched the clock, listening to the rhythmic flow of his words, though I couldn't understand a single one. When he finally finished, he looked at me with a broad smile, clearly proud of his performance. He seemed convinced that his poem was all I needed to take on his case. I tried again to get some actual details about the incident, what had happened, where, when, how, but he refused to elaborate. He was adamant that the poem contained everything I needed to know. It was a bizarre situation. I couldn't help but wonder what he expected to achieve with this approach. Did he think the poem would move me to tears and compel me to take his case? Was there some hidden legal argument in the verses? In the end, I had to tell him that we couldn't proceed without more concrete information. He seemed disappointed, but left without much fuss. However, he spent the next hour or so outside my office, reciting the poem to himself or anyone who would listen. It was a surreal experience, one that left me both bemused and curious. Even now, I sometimes wonder what was in that poem. What story was he trying to tell? What was his thought process? It's a mystery I'll probably never solve, but it certainly made for an unforgettable day at the office. Story 10. It was a nightmare that wouldn't end. I was a graduate student, living in a small apartment, trying to juggle my studies and a part-time job. The last thing I needed was trouble with my neighbor's dog, but trouble found me anyway, in the form of a pit bull that seemed to have it out for me. The first time it attacked me, I was caught off guard. I was heading out for class when the dog lunged at me from the neighbor's yard, sinking his teeth into my leg. I managed to shake it off, but the bite left me shaken. I called the cops, but they told me to contact animal control. Animal control wasn't much help either. They said they could only hold the dog for 12 days before they had to return it to the owner. I hoped the owner would take better care of the dog and keep it away from me, but that was wishful thinking. The second attack happened a few weeks later. This time, the dog had caught me as I was coming back from the grocery store. I dropped my bags and fought it off, but not before it tore into my arm. I had to get 6 stitches. Once again, I called the cops, and once again, they referred me to animal control. The third attack was the last straw. The pit bull came at me with a ferocity that I had never seen before. It bit into my leg, and I felt the sharp pain radiate through my body. In a desperate attempt to defend myself, I grabbed a nearby piece of wood and struck the dog, breaking its teeth and ribs. I was bleeding and in pain, but adrenaline took over. I dragged the dog to my neighbor's house, opened the door, and threw it inside. It was a stupid and reckless move, driven by frustration and fear. When the cops arrived, the dog's owner and her roommate were furious. They accused me of attacking their dog for no reason. Despite my injuries and the police and animal control reports, I spent a night in jail for criminal mischief, a Class C misdemeanor. I had a strong case. I had documented my injuries with photos, hospital bills, and reports. But the new district attorney, eager to make a name for herself, tried to escalate my case to a felony. It was an absurd overreach, and the judge saw right through it. He dismissed the case immediately and granted me an expunction. Looking back, I realized how dangerous my actions were. But in that moment, I felt cornered and desperate. Now, with the ordeal behind me, I can focus on my studies again, hoping to put the terrifying encounters with that dog far behind me. Story 11. In my time as a receptionist at a small personal injury law firm, I quickly learned that the job wasn't just about answering phones. It was also about filtering through some of the most bizarre and outlandish claims people you could think up. One of the most memorable calls came in on my second day. A woman was adamant about suing her cat's veterinarian for malpractice, claiming that her cat had scratched her, which she alleged led to liver failure and a slew of other health problems. Her argument was a convoluted one. She believed that her cat had some obscure disease which the vet had failed to diagnose. She was convinced that this undiagnosed condition had somehow transferred to her via the scratch, causing all her subsequent health issues. It was one of those moments where I had to stifle a laugh, unsure of whether she was serious or not. I was still new and didn't yet know how to handle such bizarre situations. So I put her through to one of the attorneys, thinking they'd know better what to do. After listening to her story, the attorney politely but firmly told her that our office couldn't assist her. We didn't specialize in veterinary malpractice or any form of medical malpractice for that matter. Moreover, the whole situation sounded like a one-way ticket to Crazy Town. The woman's logic was flawed at best, and there was no clear link between the cat scratch and her liver failure that we could see. Later, I learned from some colleagues that this might have been a case of cat scratch fever, a legitimate, though rare, bacterial infection that can be transmitted from cats to humans. In theory, this could lead to health issues, but the woman had presented her case as if she was simply looking for a cash payout. She didn't have any evidence linking her symptoms to a specific disease the cat might have carried, nor had she brought her cat in for testing with the relevant symptoms that could lead to such a diagnosis. Our firm primarily handled car accidents and similar personal injury cases with zero expertise in veterinary issues. We received calls like hers all the time, people fishing for compensation based on tenuous or bizarre claims. In her case, even if there had been a legitimate health issue, she would have needed to consult a more specialized attorney who could navigate the nuances of veterinary malpractice, which isn't a straightforward field. It was an early lesson in the job. Sometimes people have genuine concerns, and sometimes they're just grasping at straws, hoping to find someone to blame for their misfortunes. Either way, it was crucial to steer them in the right direction, even if that direction was gently out the door. Story 12. In the world of law, sometimes you find yourself caught in a web of litigation with no choice but to navigate through it. One case I handled involved a man who sold and leased cars, and it started off innocuously enough. A woman, employed by a company that encouraged carpooling, drove a company van to work. She kept the van at her home and used it to pick up colleagues, ferrying them to work and back. One morning, she stopped at a traffic light, and another driver failed to stop in time, lightly bumping into the van. The woman and the other driver both got out, inspected their vehicles, and agreed there was no visible damage. They decided to part ways without exchanging further information or filing a police report, as it seemed like a minor incident. However, things took a complicated turn when one of the passengers in the van later claimed to have been injured in the minor collision. She went to a lawyer who decided to take legal action not only against the company that owned the van and the driver, but also against every passenger present in the vehicle at the time of the accident. The lawyer conducted depositions for each passenger, presumably fishing for liability or insurance information. The lawyer then took things a step further, contacting the auto insurance companies of each passenger, demanding coverage for the alleged injuries. It was a classic case of casting a wide net to see if any claims might stick. One of the passengers admitted they didn't own a car, but mentioned that their sister did. This led to the lawyer suing the sister, attempting to claim insurance from her. The situation reached my client when the lawyer discovered that the sister's car was leased from my client's company. Since the leasing company provided the insurance, the lawyer sent a demand letter to my client, seeking coverage for the supposed injury. It was a case that spiraled out of control, dragging in individuals who had little to do with the incident. The legal strategy seemed to be to sue anyone remotely connected to the situation in the hopes of securing a payout. This kind of litigation can be a nightmare for those caught in its web, especially when they are blindsided by demands for insurance coverage or court appearances over an incident they barely recall. In the end, we had to represent my client, despite the absurdity of the situation. The case illustrated how, in the legal world, one small event can mushroom into a complex legal battle, pulling in numerous parties along the way. It was a reminder of the unpredictable nature of litigation and the necessity of being prepared to defend against even the most tangential claims. Story 13. As a prosecutor, my job isn't to represent individuals but to serve the government, deciding how to pursue charges, offer plea bargains, or potentially drop cases altogether. A few months ago, I encountered a case that left me both bewildered and frustrated. The defendant was a 70-year-old man with no prior criminal record. His alleged crime? Shoplifting a sandwich. From the case file, it appeared he had walked into a store, picked up a sandwich, and eaten it right there. He genuinely believed he had paid for it, perhaps due to confusion or simply a lapse in memory. When I saw him in court, he looked petrified. His hands trembled, and his eyes darted nervously around the room. It was clear that this was a deeply unsettling experience for him. I was angry that the case had escalated to this point. A simple misunderstanding by an elderly man had turned into a criminal charge, something that seemed wholly unnecessary and harsh. There was no malice in his actions, no intent to steal. It was just an honest mistake. In the courtroom, I made the decision to withdraw the charges. I wished him well and watched as a relief washed over his face. It was a small gesture, but it felt right. Cases like these make me question the system sometimes, wondering how such minor incidents can snowball into something far more serious than they need to be. Story 14. One of my favorite stories comes from a former teacher of mine who worked for a major video game publisher, one of the big players in the industry. He once shared an amusing and cautionary tale about how the company handled lawsuits over bad games. Typically, if someone sued them for a small amount because they were unhappy with a game, the company would just pay up. It was simpler and cheaper than navigating the legal system, especially when international jurisdictions were involved. But one case stood out. A law student, representing himself, decided to sue the company because he thought a game was terrible. Unlike the typical small claims, this guy tried to throw the book at them, making a fuss and demanding more than just a refund. The company, usually content to settle quickly, decided to make an example of him. Instead of their usual strategy of quick settlement, they fought back. The lawsuit escalated, with both sides investing significant time and money. The company had their legal team, experienced and well-resourced, while the student, likely overconfident in his legal prowess, was getting deeper into a battle he couldn't win. The whole situation snowballed, becoming more complex and expensive for the young man who had to deal with legal bureaucracy and travel expenses. Finally, the company decided to settle, but with a twist. They arranged for a hearing in front of a judge where they theatrically placed the price of the game, about $60 USD, on the table in cash. They then suggested that the law student take the money and drop the case. The judge found the offer more than fair and quite plainly told the student that if he refused the settlement, he could face penalties, essentially fining him for wasting the court's time. In the end, the student had spent around $5,000 USD on the case, including bureaucracy and travel expenses, only to be handed $60 in cash. His expression reportedly said it all: frustration and disappointment. He had invested so much in trying to get back at the company, only to end up with a paltry sum that didn't even come close to covering his expenses. Ironically, some gamers might see this as a victory, proving a point against a giant company regardless of the cost. But, in reality, it was a harsh lesson in the pitfalls of self-representation and the practicalities of the legal system. For the company, it was a small expense to protect their interests and set a precedent. For the student, it was an expensive reminder that the legal system doesn't always align with personal crusades, especially when the stakes are so trivial. Story 15. Working in IT for a family law firm, I didn't often get involved in the cases directly, but there was one unforgettable incident that gave me a front row seat to the complexities and occasional absurdities of family law. A woman came into our office requesting an attorney to review her divorce case. She was a striking figure, both in presence and demeanor, and seemed adamant about getting a divorce on the grounds of abuse, claiming her husband had been beating her. The attorney she met with, a seasoned professional in his late 60s, patiently listened to her story. After hearing her out, he suggested a simpler, more straightforward approach, filing a no-fault divorce. Given the short duration of the marriage, just a few months, he believed this would be the quickest and least painful way to end things and separate from her alleged abuser. But instead of relief, his suggestion triggered an unexpected reaction. The woman exploded in anger, yelling and throwing things at the attorney. She even began hitting him, despite his age and the shock of the situation. Amidst the chaos, she blurted out that if she had successfully divorced the same man 4 times before, she could certainly do it a 5th time. This bizarre revelation left us all stunned. How could someone repeatedly marry and divorce the same person under such circumstances? Our firm decided not to take her case. The whole situation seemed far too volatile, and there were too many red flags. However, our sister firm, the one from which our firm had originally split off, ended up taking the husband's case. What they uncovered was a deeply troubling situation. Contrary to her claims, the woman had been the abusive party in the relationship. She had allegedly been holding her husband and their children hostage emotionally, using threats of false accusations to control them. She would threaten to tell the police that he was abusing the children or beating her, manipulating the legal system to her advantage. This case was a sobering reminder of how the legal system can sometimes be manipulated and how difficult it is for male abuse victims to be taken seriously. Society often overlooks or doubts male victims of domestic abuse, especially when the abuser is a woman. The husband's predicament was particularly tragic. He was trapped in a cycle of manipulation and false accusations, with his children's safety also hanging in the balance. In the end, the truth came to light, and the husband was able to get legal representation that understood the full scope of his situation. It's uncertain what happened afterward, but one can only hope that he and the children found some peace and stability away from such a toxic environment. The story left a lasting impression on me. It highlighted the complexities of domestic abuse cases and the importance of looking beyond the surface claims. It also reinforced the need for the legal system and society to support all victims of abuse, regardless of gender,